Amanda, that earlier problem was like every time a noise at CCA would come out, it would capture that, so it would mute me, and I think that's what was going on.
I think it is too, because we've never had that particular problem before.
Right.
It sound like noises that weren't coming from any of the rest of us.
Yeah. Zach, do you have a blank PSI request that you'd be able to fill out and send over to probation?
Yes, Judge. I can. I have a digital of it. Do you want me to send it to you, or do you want me to send it to someone else?
Just go ahead and send it to me. I'll kick it over there.
Okay, Judge, we can take care of that. Unfortunately, my computer's occupied by this hearing, but I will do it with Mr. Brown as soon as we're done.
No worries. All right. Let's get started then. We're going to be on the record in case number 2021 CR 60, captioned State of Kansas versus Joseph Marvellus Brown. Would the parties announce their appearances, please?
May it please the court, Christopher Schneider, Assistant District Attorney, appears on behalf of the state of Kansas via Zoom.
This court, Joseph Marvellus Brown appears in person and by counsel Zach Anthony, also via Zoom.
All right. We're here set down for a plea today. However, folks, I think I'm right. There hasn't been a waiver or a prelim yet. Is that correct?
That is correct.
All right. So, Mr. Anthony, have you had a chance to talk to Mr. Brown about his right to a preliminary hearing and what he wants to do with that today?
Yes, Judge. We've had an opportunity to discuss the various rights that he has with respect to the criminal justice system, including the right to a preliminary hearing. We would waive that right at this time so that we could go forward with the plea hearing as scheduled.
All right. Is that correct, Mr. Brown?
Yeah. Yes, Your Honor.
All right. And Mr. Schneider, on behalf of the state, you also waive preliminary hearing?
Yes, Your Honor.
All right. I'll find both parties have waived preliminary hearing. I bind the defendant over for trial as charged. I assume, Mr. Anthony, you waive formal reading and or pleas of not guilty until we finish with this today?
All of that is correct, Judge. Thank you.
All right. Mr. Brown, now we're ready to take up your plea. Here's what we're going to do. I'm going to ask you a bunch of questions. If I ask you something that you don't understand, I need you to tell me that. And you and I will talk about it until we're sure we're on the same page. If at any time you want to talk to Mr. Anthony in private before you answer a question, just tell me that. He'll mute your microphone. You guys can talk and then come back when you're ready. Okay? Mr. Brown?
Yeah.
He said yes, Judge.
Oh, okay. So I'm going to need you. My court reporter's taking everything down. So make sure you speak up and speak loudly because I didn't hear anything there. And to get started, I need to have you sworn in. So if you'll raise your right hand, my court reporter will swear you
in. Excuse me. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You just speak up. I'm sorry.
Yes.
Thank you.
All right. Mr. Brown, how far did you go in school?
What grade?
You read and write English okay?
Yes.
All right. As you sit here today, are you under the influence of any alcohol, drugs, or prescription medicine that might cloud your mind, keep you from understanding what you're doing?
No.
All right. You feel like your mind's clear today?
Yes.
Do you know what you're charged with?
Yes.
And you understand you don't have to change your plea from not guilty to guilty. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial on these charges. You understand that?
Yes.
At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. Mr. Anthony would assist you throughout that trial. He could cross-examine and confront all of the state's witnesses, challenge their evidence. He could call any witnesses you wanted called, and if they didn't want to come to court, he could use the subpoena power of the court to make them come. At that trial, you would have a right to testify, but you'd also have a right not to testify. And if you decided not to take the stand, the state couldn't use that against you. In other words, Mr. Schneider couldn't get up and argue, well, you all should convict Mr. Brown because he didn't take the stand, tell his side. You understand all those rights?
Yes.
All right. And if we had that trial and at the end of that you were convicted, you would have the right to appeal that conviction to the appellate courts. If you didn't have money to do that, a lawyer would be appointed to do it for you. You understand that too?
yes,
All right, if we do this plea today, you're going to be giving up all those rights. There's not going to be a trial of any kind in this case. You understand that?
yes,
All right. I'm going to share right now the plea petition that your attorney sent me. Can you see that up on the screen?
yes,
You have a copy there with Mr. Anthony?
yes,
All right. Is this look like the same document that you have there in front of you?
yes,
All right. I'm going down to what we call the plea agreement portion of this. I'm going to read this to you, and I want to make sure that we all agree that this is what the parties are agreeing to. You're going to be pleading guilty to counts 1 and 2, both of which charge you with violation of offender registration. That's a level 6 non-person felony. The other counts are all going to be dismissed. The parties are going to recommend to the court that you get consecutive terms, in other words, that they run one after another, but that you also get probation. Is that your understanding of the plea agreement?
yes,
Has anybody promised you anything else to get you to plead today?
no,
Has anybody placed any force or threats against you to make you plead today?
no,
All right. I see here that the parties are agreeing for a joint recommendation. You understand that I will listen closely to those recommendations and everything that anyone has to say about your sentencing. But I'm not party to these negotiations, nor am I bound by them, and I can give you any sentence that the law allows me to. Do you understand that?
yes,
All right. Now, gentlemen, do you have an idea of what you believe Mr. Brown's criminal history score is going to be?
I believe an H for purposes of this case, Your Honor.
Judge, he may, I'm aware of at least a non-person crime out of the state of Missouri. He may be as much as an F. I think he's probably a G, but we don't believe he has any person felonies, Judge.
Okay. All right. So, Mr. Brown, I know that Mr. Anthony would have gone over with you your criminal history and where you might fall on that sentencing grid, and then combine that with the crimes that you're pleading guilty to give you an idea of what kind of sentence you might be subject to. Is that all correct?
yes,
Okay. Now, until I see a PSI and everybody comments on that, I don't know what your criminal history score is. So I have to advise you of what the very maximums that anyone could get if they have the worst possible criminal history. Do you understand that?
yes,
All right. I see here that Mr. Anthony says that the maximum is 65 months in prison and a fine of $200,000 with a post-release supervision of 24 months. Do you understand those are the maximums?
yes,
So what he did here was he took the A score for your first count and the maximum box in that. And then for the second count, he used the I box because they wouldn't count your criminal history, and added those together plus the fines. You understand that?
yes,
And that's the maximum that anybody could get for pleading to these two. You understand that?
yes.
Okay. Mr. Brown, do you have any questions for me about anything that we've gone over today?
No, I do not.
Knowing all of this, do you still want to go forward with this plea today?
Yes,
All right. Mr. Anthony, do you know any legal reason why your client should not plead guilty today?
No, Judge.
All right. Then I'm going to ask you, as to count 1, charging you with violation of the Kansas Offender Registration Act, how do you plead, guilty or not guilty?
guilty,
As to count 2, charging you with the same thing, violation of the Kansas Offender Registration Act, how do you plead, guilty or not guilty?
guilty,
All right. Now listen closely, because I'm going to ask Mr. Schneider to tell me what he thinks the evidence in this case would be. And when he's done, I'm going to ask you if that's what happened, okay? Mr. Schneider.
Your Honor, if evidence were to be presented in this case, it would show that on May 13th, 2008, the defendant was convicted in the criminal court of Shelby County, Tennessee, of the crime of unlawful possession of a controlled substance with intent to manufacture, deliver, or sell that substance being cocaine, in their case number 0704788. As a result of that conviction, Mr. Brown is required to register for 15 years with the sheriff of the county in which he resides, is employed, or attends school in the state of Kansas. He's required to register during the month of his birth and every 3, 6, and 9 months thereafter. His date of birth is September 24th, 1963, meaning that he is required to register with the sheriff in September, December, March, and June. Judge, as to the charge in count 1, during the month of June of 2019, while a resident of Wyandotte County, Mr. Brown failed to register with the sheriff as required by statute. The statute makes each succeeding 30-day period in which he fails to register a separate and distinct offense. And Judge, as to count 2 of the information, between the first day of July of 2019 and the 30th day of July of 2019, while a resident of the state of Kansas and of Wyandotte County, the respondent failed to register with the defendant failed to register with the sheriff.
Thank you. Mr. Brown, is that what happened?
Yes.
All right, thank you. I will find the defendant has freely, voluntarily, and intelligently entered his plea of guilty today. He understands the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis for a finding of guilt, and the defendant has acknowledged that factual basis. Therefore, I will find he is guilty of both counts 1 and count 2. Pursuant to the plea agreement, the other counts are hereby dismissed. I'm going to order a pre-sentence investigation be prepared and continue sentencing until that is received. I've talked to the parties before we went on the record, and I'm ready to set a Zoom sentencing on May 28th at 9 o'clock in the morning. Mr. Snyder, Mr. Anthony, you both, that date and time worked for you, correct?
Yes, Your Honor.
Yes, Your Honor.
All right. So, Mr. Brown, a couple of things I have to advise you of. As a convicted felon, it's prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. This is not a registrable offense, but the requirement for registration in the old offense still remains. Look, I personally have some problem with the severity of these crimes of failing to register. Look, I don't have a lot of thought for people who are like trying to conceal themselves, but I think a lot of people get caught up in this because they just don't get around to doing what they need to do. Okay. And the worst part about this is every time it happens, it gets worse for you, right? Because at the end of this, you're going to be on probation. So if you were to fail to register again, not only would you get new crimes, but they'd file a motion to revoke your probation for new crimes. So you could end up serving not only this sentence, which will be a long one, but the next ones as well. Okay. So make sure that you do a good job figuring out when you need to register and getting in there and doing it. Okay. All right. Thank you, Mr. Brown. Yes.
Mr. Anthony, did you want to email me the plea petition? If it's Word, I'll electronically sign it. If it's in the PDF form, I'll go ahead and print it out and sign it and submit it to the court on Monday.
You should have it, Chris. I emailed you and the court about an hour ago before Mr. Brown had gotten here. So check and see. If you don't have it, just let me know. Okay,
thank you.
Any chance that I can just show in my copy, Mr. Schneider, that you verbally approve? Type that in and initial it?
We're on the record, Judge. I'm fine with that.
All right. That'll, I think, save everybody some time.
Thank you.
Okay, I'll do that and I'll get it over there. Anything else for our record today?
No, Your Honor.
We're adjourned. Y'all have a good weekend.
Thank you.
Thank you.
I'll see you at 1, Judge.
You bet.